As a prosecutor, what do you take away from those 2.5 minutes of Donald Trump on tape?
The best possible evidence when you're a prosecutor is the defendant on tape admitting to the crime. So that's what you have here. I mean, this really is not about the facts. This is about when is the trial going to happen, and will the jurors actually obey their oath to follow the law? I mean, you have a person who's charged with the illegal retention of documents that are national defense information, i.e. classified information. He's on tape where he talks about being given by the Department of Defense a document that he says is classified. That's the crime. So this, to me, is not about a discussion of the facts anymore. This is just about getting to trial and will people follow their oaths to office.
And he admits on that tape that he's not the president anymore. He can't declassify it. That's sort of some strange theory he had floated out there that he had the power to declassify it. So how does this fit into, as you say, this is damning on its own, but how do you think this fits into the larger case that Jack Smith is building around this? How does this plug into that story?
Well, there is an interesting issue because if you are the defense, you have to do something about this. That's their job. And one of the things they can do is say that this tape should not be admitted at this trial, because this is a discussion that's happening in Bedminster, right. And there's a description of this tape in the indictment, but it's not actually charged in the indictment. In other words, it's not one of the 31 counts. Now, there are ways in which it could be admissible, but here's the chess game. If Donald Trump, if his team moves to say this should be excluded from the Florida trial, that just goads Jack Smith to bring it in Bedminster, where it can be charged. And I can see why he didn't do it yet, because you don't really, it looks sort of like overkill to charge somebody in 2 different locations. But if he does that, if he says that shouldn't come into the Florida trial, that's just going to be an invitation for Jack Smith to charge it in Bedminster.
And Mika, this is a proposition that Andrew raised a couple of weeks ago. We had him on the show to discuss that there could be another venue for all of this, in addition to, not instead of, Florida, which is New Jersey.
Right. I was wondering about that. And Andrew, I'll follow up with you saying that's the crime on the audio tape. I mean, obviously, we've already heard Donald Trump say, and we will hear Donald Trump say, no, I wasn't holding up a classified document. I was just holding up newspaper clippings. Isn't there more corroborating witnesses and evidence needed to prove a crime here?
So the answer to that is yes, except even the tape itself. I mean, you can just look at the reaction of people to sit there and say this is classified. Right. He can't be holding up the New York Times and be saying, oh, this is classified. People would be, what are you talking about? It's a magazine or it's a newspaper article. Also, there's a part of the tape where Donald Trump is saying to a staffer, let me see that. So it's clear he's being given that by somebody. You can be sure that Jack Smith has interviewed all of those people. You do not put something like this into an indictment without having a complete record of exactly what happened. So there is more to come. Again, remember, an indictment, you only put in certain things. The sort of evidence that you get from witnesses and witness interviews would be very rare to include in an indictment. So I think this is one where it is an incredibly strong piece of evidence.
So, Andrew, we want to get your reaction to a couple other developments in this case. One would simply be that Judge Aileen Cannon has ruled that listed 84 potential witnesses would not be kept secret, which is something the special counsel had asked for. And then secondly, just in terms of the chronology, there's a hearing scheduled for July 14th, but now the trial itself not set to start until December.
So let's talk about the trial date, since that's really the most important. You know, the government asked for a sort of real and firm trial date of December. There had been a sort of what I would call a control date in August. Right. So this isn't really Jack Smith saying, oh, we want to put the trial off. This is really saying, we'd like an actual firm date given the reality of discovery and motion practice, et cetera. The judge has said to the defense, you need to respond next week to how this is going to work. So we need to hear from you, and then I will make a decision about the trial date. I think that is one of the most important decisions in this case, is will there be a trial before either the Republican nomination or the general election? So that remains to be seen what she rules on that. The 84 witnesses is kind of interesting because the judge, although she was kind of snarky in the way she ruled on this, she basically said, why don't you just give the other side the list of the 84 witnesses I do not need to see it. Remember, the magistrate judge's order, which is you cannot speak to these people, is still in place. She didn't say that she's overruling that. So this is more an issue of what's going to get filed on the public record, because remember, the media said, if it's filed, we want to see it. She could have just said no to the media, but instead she said, why are you even really filing this with me? I don't really need to see it.
And the special counsel wants to keep that secret to protect those witnesses.
Absolutely. You know, we did the same thing when I worked for special counsel Mueller because of the intense media scrutiny. People who are sort of lay citizens and the amount of opprobrium and sort of the crazies out there, if their names get out and their social security numbers and their addresses, you want to protect them from that.
And Donald Trump is always happy to sick his supporters on witnesses like that.